Well, it looks like we have a pretty good number, so I'm going to go ahead and get started. Just want to thank everybody for joining us today. I'm Lindsay Wyrick, and with me today is Jenny Smiley. We are both attorneys at the law firm of Cobb Martinez Woodward. It's a litigation boutique firm, and I am a partner with CMW. I've been practicing about 13 years, and a large part of my practice focuses on representing attorneys in malpractice lawsuits and with ethics issues that arise. And so I regularly represent attorneys and other types of professionals. I also have been on the DWLA board for several years and have the honor of serving as treasurer for that organization this year. And today we are here to talk to you about tips and potential traps related to the formation of the attorney-client relationship. So just like if you remember the childhood book, Are You My Mother, where a baby bird is wandering around in search of his mother, we hope that after this presentation, you and potential clients of yours are not left wondering, are you my lawyer? Just before we get started, I want to add that if you have questions throughout the presentation, feel free to put those in the chat feature. We'll also hopefully have a few minutes at the end where we can take questions via that chat feature as well. As far as CLE credit, make sure you stay on until the end. Our executive director is going to put the CLE link in the chat at the very end, and you'll have to go to that link and fill out a form to get your CLE credit. So make sure that you do that. And so with that, we're going to get started with our presentation. I'm going to turn it over to Jenny. She's going to introduce herself and get the discussion started.
Great. Well, hi, everyone. My name is Jenny Smiley, and I graduated in 2015, so it's been about 7 years. And I also represent lawyers and do a lot of legal malpractice defense. So we have a good topic for you guys today. Let me start our deck here. So here is our PowerPoint. I'm going to talk about the case law kicking it off here, and why it is important is because so in a legal malpractice case, there are it's negligence normally and breach of fiduciary duty. And the first element that the plaintiff would have to prove is whether there was a duty. So that is normally whether there is an attorney-client relationship with the plaintiff, between the lawyer and the plaintiff. And it's also important to know who your client is for attorney-client privilege discussions. So you have to have a client to have the attorney-client privilege. So the cases tell us the attorney-client relationship is contractual. A contractual relationship in which an attorney agrees to render professional services for a client. There are a bunch of cases on this. I think the most popular one that we hear about all the time in our office is Parker versus Carnahan. So that lays out the law, and other cases have discussed Parker a lot. To establish this relationship, the parties must explicitly or by their conduct manifest an intention to create it. The cases use that phrase all the time, and you'll read it all the time when you're looking at this issue. So in other words, an attorney-client relationship may be established either expressly, like in an engagement agreement, or by impliedly from the conduct of the parties. So there's an objective test that the courts will use to determine if the attorney-client relationship is formed. The courts look whether there was an agreement or meeting of the minds and use objective standards of what the parties said and did not look to their subjective, the courts do not look to their subjective states of mind. So this means also that the attorney-client relationship cannot be implied based on the conduct of only one party. So if you're litigating this issue, the plaintiff is going to say, I believed they were my attorney. The good news is that the objective criteria is what the court is going to look at, but the plaintiff is going to say that all day long. So for implied attorney-client relationships, occasionally this will be implied from the party's conduct. For example, an attorney-client relationship may arise by implication if the lawyer knows a person reasonably expects him to provide legal services, but does nothing to correct that misapprehension. So regardless of whether the attorney-client relationship is expressed or implied, however, there still be some manifestation that both parties intended to create an attorney-client relationship. Therefore, one party's mistaken belief is not sufficient by itself. So some examples of these objective criteria are whether there was a written engagement agreement, whether fees were discussed, whether there's evidence of an agreement to represent the client. Did someone say that? Did someone say, I will represent you? So you don't need a written agreement to form the attorney-client relationship, except for, and this is a whole other topic, which we're not going to get into today, contingency fee agreements need to be in writing. And that is in the Texas Disciplinary Rule of Professional Conduct 1.04D. So, but in general, though, you don't need for an hourly agreement or some other kind of arrangement, you don't need an engagement agreement to be in writing. But best practice is that it should be in writing. So the courts are going to be looking at, did the alleged client manifest an intent to the lawyer that the lawyer provide them legal services? So I've had a case on this, and we litigated this issue for 2 years. And I thought it would be helpful to kind of see how this structure plays out. And for us, it was a summary judgment. We had a long list of questions we asked the deponent, about these objective criteria, and he didn't have answers on that. And then we had an affidavit and deposition testimony from our client, the lawyer, proving up, right, that there was no attorney-client relationship. So I just jotted down some either questions for your deposition or things to put in your client's affidavit on this issue. So the for the putative or alleged client, try to establish that there was no agreement, that there was no discussion of legal services to be provided, that that person did not pay any fees to the lawyer, that the potential client didn't get any invoices or didn't pay any invoices from the lawyer, that they didn't pay any expenses, and also too, if there was really an attorney-client relationship, the client should be able to explain what the terms of the engagement were. And so if you ask them what were the terms of this engagement and they can't say what it was, then that would be some good objective criteria to add to your motion. So example, what were the agreed upon hourly rates? What was the scope of the engagement? What matters would be handled? If there's not an agreement on the scope of the engagement, that would be good objective criteria to disprove an attorney-client relationship. So did they ask the lawyer to represent them? Were they represented by other lawyers at the time on the same matter? And this was an issue in our case. We had emails from another lawyer saying, yes, I represent him on that matter. And that was really helpful objective criteria that we presented to the court and said, look, there was another lawyer representing him. We know, more than one lawyer can represent someone at the same time, but in this case, it was not us. And this is objectively shows that the client knew someone else was representing him, not this other firm. So the testimony of the lawyer is just as important to establish that there was no attorney-client relationship between the firm and the alleged client. So the things for the law firm to prove up would be, did the firm run conflicts? Did the firm prepare an engagement letter? Did the firm or lawyer send invoices to this person? Did the lawyer send emails to this person? What did the email say? Did the law firm or lawyer tell the client they were representing the client? Did the firm file anything for this person? Did the firm make an appearance for this person? Did they represent to others that they were representing this person? So did the firm give legal advice? And then did the firm record any time to this client matter? If all of those are no, that's some pretty strong objective criteria that the attorney-client relationship was not formed.
So now we're going to talk about technology's impact on the formation of the attorney-client relationship. We all use technology for our law practices, and even, now I think we're often meeting potential clients and maybe even forming attorney-client relationships over technology. That I think that's even more true after the pandemic. And we all know with technology, we tend to move a little bit faster. We oftentimes tend to be less careful in those sort of exchanges. And so I want to look at a few different mediums of technology that we may be using to talk to potential clients and talk about just some ways to protect yourself with those different mediums. So first, we're going to talk about your firm website. So I'm sure most of us have an internet presence with our law firm. And a lot of law firms' websites have a contact feature where you can directly through the website contact either an individual lawyer or contact the law firm, and that will be routed to someone at the law firm. And so while you likely have some controls on what information is coming through that, through those email links, and probably even a limitation on how many words can be transmitted, you don't have control necessarily over, exactly what the client is saying or potential client. They're just sending in information. And so it is wise with those types of email links via your website to have a disclaimer that the client has to accept before they're allowed to send any information to the law firm. And here's a few bullet points for those types of disclaimers. It should say, do not send information that you contend that you believe is confidential. So you don't want someone you don't even know, someone you haven't even had a discussion with, sending you confidential information. They agree that by submitting this information, there's no attorney-client relationship formed. And additionally, that the information they do submit will not be treated as confidential. And so, why is this important? Well, the ethics opinions talk about the fact that attorneys may owe a duty of confidentiality to prospective clients. If that prospective client has a reasonable expectation that the attorney is going to keep information they submit confidential, then there may be a duty of confidentiality owed to that prospective client. That can come back and be an issue later when you're trying to represent somebody else. That could come up that could be a potential conflict of interest. So potential client A sends you information that they believe is going to be kept confidential. You don't end up representing client A. A few years down the road, client B comes to you and wants to represent you in a matter that is adverse to client A. You don't think you've ever represented client A, but if you have confidential information of client A, you may be in a conflict situation from representing client B. So that's where this really is important for our practices. So I've cited a Texas ethics opinion here, 651. And it's really helpful as far as what these email links on your website should say. And it's essentially the bullet points that I have on this slide. And it makes the point that the client should accept that disclaimer before the information is sent via the website. And so the opinion says that if an effective warning notice is not provided to prospective clients with these email links, that lawyers who receive confidential communications from a prospective client may have an obligation to protect that information down the road. Whereas if a law firm has a sufficient warning notice with these bullet points, the law firm may use that information for the benefit of current and potential clients, even if it's adverse to this prospective client. So you want to have this type of disclaimer on your website for that purpose. Just a note as well about the live chat features that we often see with lawyer websites. And while I think a lot of those are automated in terms of the response, just make sure that those communications also include appropriate disclaimers about not sending confidential information, and this does not create an attorney-client relationship, and that there's no sort of promise to perform legal services that's discussed over that chat feature. So moving on, I just wanted to have a note here about text and email communications. I think a lot of this is obvious, but we move at such fast a pace and these communications sometimes that I think we forget some of these tips. And so, as I said before, a lot of us are communicating with clients, potential clients, over text and email. So I would just have a caution here about friends and family. And what I mean by that is you're in a text exchange with a friend or a family member, maybe even, a business associate, and some, you're talking, and then suddenly they're asking you for an opinion about something which really is legal advice. And it's a casual conversation, and you want to be helpful. So, you respond and keep on going with the conversation. I'm sure this has happened to all of us. And so just beware that by giving legal advice to friend, family member, associate, you may be creating an attorney-client relationship. And while typically that's fine in the context of friends and family, of course, there's situations where that goes wrong. So just be cautious about sort of the off-the-cuff legal advice that may pop up in those communications. And then and let me just say, this is a sort of a general practice tip. Of course, there are exceptions, but at our firm, we have a policy that we try not to text with clients. And I would say that also goes with prospective clients. So if you meet someone one way or the other and you're texting about the potential attorney-client relationship, I would try to switch that communication over to email. It's just inevitable that we are not as careful and as formal in text exchanges as we are in email communications. It's just sort of human nature. And so in all your communications with prospective clients, treat them as formal communications, as if you're writing a letter. Be thoughtful, clear, and professional. And just a couple of pointers that come from the case law in communicating with prospective clients is avoid referring to them as a client until they are actually your client. There's a case out of the Houston Court of Appeals looking at whether Aiken Gump had formed an attorney-client relationship with a prospective client. And the court looked at the time records of Aiken Gump and found that those referred to the prospective client as a prospective client instead of just a client. And that was a factor that the court considered in finding that there was no attorney-client relationship. So be cautious about the language that you use with that prospective client. And then be clear, we're going to talk about fee agreements in a bit, but be clear and upfront from the beginning with the potential client that these are only preliminary discussions, and that a fee agreement is going to be required to begin the representation, so that if there's no fee agreement entered, that's a factor weighing in favor of no attorney-client relationship was formed. I had a case where a co-defendant was arguing that there was no attorney-client relationship, and that the law firm involved was Strasburger, and Strasburger had multiple conversations with the potential client for months about whether they were going to represent them. And of course, through that, they learned some facts about the case. And that prospective client ultimately claimed Strasburger did represent them and claimed malpractice. And Strasburger argued, hey, we said from the beginning that we were not going to represent you without a fee agreement. We were actively negotiating the fee agreement, and you, prospective client, were involved in those discussions and knew that. And the Court of Appeals found that there was no attorney-client relationship, that the client knew that there needed to be a fee agreement entered. That had not happened. And so while certainly some information had been exchanged, there was no attorney-client relationship there. And just one last point on this, in any exchange with a potential client, gather only the minimum information that you need to perform a conflicts check and to consider the potential representation. There are going to be matters where, it may be a significant matter, it may be complex in some way, where you need quite a bit of information to evaluate the case and to decide if you're going to take the client. But just be mindful, in addition to the disclaimers about, that this information is not confidential, just be mindful of what you're gathering and try to gather only the minimum information needed. And then the next topic is social media. And of course, we all use social media, and a lot of us use social media for our practice, for our law practices. And in fact, the ABA conducted a study in 2020 on technology, and 77% of the respondents said that they use social media for their law practice, with LinkedIn being sort of the primary medium for that. And so I think what we all have sort of heard in the past is the legal advice at the cocktail party. You're just chatting with someone at a cocktail party and they ask you for legal advice. That now happens over the internet, and particularly with social media. And so just a few words of caution here. When of course, the rules still apply in social media, the rules of confidentiality, the rules of truthfulness, the rules of not misrepresenting your law practice or what legal services you can or will provide. Those all still apply no matter the forum. And so be careful with online forums, social media posts where there may be comments, blog posts, things like that. So particularly with things like Facebook and LinkedIn, where you may be sending a request to someone, or you may be commenting on something. And oftentimes we're trying to be helpful, right? But just know that if you're commenting on a post or that someone has posted, that is where you are providing legal advice. If you're providing legal advice to someone about a particular legal need, that could be construed as attorney-client advice, and that you have created an attorney-client relationship. And so even when there's areas where you can be helpful to someone online, just be cautious with providing that advice. And then with friend request or LinkedIn request, just be cautious that if you are reaching out to someone, sending a request with an offer to provide legal services, and this needs to be to a non-lawyer, that may be viewed as soliciting legal services, which there are certain rules around that. So moving to that topic, beware that your posts or your comments, whatever, online may be viewed as advertising or solicitation. And I've cited a couple rules here, the Texas disciplinary rules, that are important to look at for this. So Rule 7.01 is the general rule about communicating concerning a lawyer's services, and it provides the general rule that information about legal services must be truthful and non-deceptive. It also defines what an advertisement is, what a solicitation is, but essentially, if you are reaching out to someone online and it's substantially motivated by pecuniary gain, that can either be advertising or solicitation. Advertising is where you don't know about a particular legal need. Solicitation is where you know about a particular legal need and you are seeking that person out. And so advertising and solicitation are allowed in certain circumstances, but you have to follow certain rules and requirements. So you want to be cautious about if your comments, posts, et cetera, rise to that level, you're in a different category in terms of the requirements. Under Rule 7.03, that specifically talks about solicitation and other prohibited communications. And essentially that rule says that a lawyer is prohibited from initiating contact with a prospective client through any live, interactive manner online. And there are exceptions for non-lawyers, there's exceptions for lawyers for reaching out to another lawyer. There's exceptions for reaching out to a family member or someone you have a close personal relationship with. But generally, if you are initiating contact with a non-lawyer about a particular legal matter online, that may be viewed as solicitation. And the reason that the rule focuses on sort of the live interactive matter is the comments talk about the fact that in that sort of live interactive matter, it's more overwhelming for the individual. It's, there's immediate responses and less time for evaluation. And so it can be more intimidating in that sort of environment for the non-lawyer who's being approached. And so that's why there's prohibitions and certain restrictions on those communications. So just sort of a general statement to wrap this up. While it's not explicitly required by the disciplinary rules, I think it's generally wise to include a disclaimer statement when interacting with others on the internet and in social media outlets. So this includes, social media posts. This includes blog posts. It'd be helpful to include a disclaimer that by providing this, this information, you are not creating an attorney-client relationship with anybody. So just some cautions there with social media. And I'm going to turn it back over to Jenny to talk about our next section.
Yeah, thanks. I remember the cocktail party example from Professor Bridge in law school, and remember sitting there and thinking, well, that will never happen. And then lo and behold, it's definitely happened to me before. And then as well as all of your points about social media, someone will I definitely get emails and texts from friends saying, what are your thoughts? What are your thoughts on this? And I respond, well, I'm not your lawyer, but so yeah, we've definitely all been there. So this next part is we put together a few, Lindsay's covered some of it too, avoiding pitfalls with potential clients. And so I just came up with very short reminders on this. And I looked at some case law for an example of what not to do, so that assuming you have an engagement agreement, which is the next section, hopefully you will, but if you don't, the implied relationship is what you would have to deal with in determining whether you have an attorney-client relationship. And so the question for the court or fact finder is whether the alleged client reasonably relied on the lawyer to provide legal services. So an example that I found of what not to do is from Perez versus Kirk and Kerrigan, which is a Corpus Christi Court of Appeals case. The Court of Appeals reversed a summary judgment that the lawyers got on this issue. So this was a case where there was a school bus accident, really horrible accident, and the driver that caused the accident was a truck driver who hit the school bus. So the next day, the lawyers for the trucking company entity go to the hospital and take the driver's statement. The driver said that the lawyers told him that they were his lawyers and were going to help him, and that the lawyers also said anything they told him would be kept confidential. So the next day they got a criminal lawyer to represent the driver, but eventually these lawyers handed over the sworn statement to the police. And so these lawyers got a bunch of causes of action alleged against them, but 2 of them were negligence and breach of fiduciary duty. And so the Court of Appeals looked at duty first and decided that the lawyers telling him that they were his lawyers and that they were going to help him was enough to imply the creation of the attorney-client relationship. So it was, there are a couple different issues going on with that, but I think the takeaway from that is be careful what you tell a person, not a client, right, but a potential client or just another person. And then also be careful of the information that you get from them. So on potential clients, maybe you're looking to get their business, but then maybe they don't ultimately become a client. You still have to maintain the confidentiality and privilege of that potential client, regardless of taking the case or not. There's an ethics opinion somewhat on this issue. Texas Ethics Opinion number 494. This was where a lawyer consulted with a husband about a divorce, and the husband paid a consultation fee, but that was their only relationship. That was the lawyer didn't end up representing the husband, but they had a conversation. The husband paid a fee, and I believe the circumstances of the wife wanted to use the same lawyer later in the same divorce. And so the opinion talks about how even with the short consultation, the attorney-client relationship was formed between the lawyer and the husband. And so the lawyer could not later represent the wife in the same divorce. So where these issues with potential clients have come up in my own practice is we had a client, a law firm, who represented a husband and a wife jointly, and she represented them, and then the representation ended and the attorney-client relationship was terminated. But then subsequently, the wife came back to the lawyer and asked about a separate matter, a different matter, and wanted some advice on that. The client's first email right off the bat, the lawyer's email right off the bat was, I can't help you. We had a joint representation and I can't help you. I'm declining to help you. But so where this came up was the husband then sued their lawyer about the joint representation, like the first matter. And the husband wanted that subsequent communication between the wife and the lawyer on the subsequent matter. So we asserted privilege and said that was, even though she declined the representation, that's a potential client about a different matter. And so it was privileged and needed to be held, like the privilege is held by the client, and we have to keep it confidential. And so there was the husband filed a motion to compel. We had the judge review these communications in camera, and the judge agreed that there is a privilege between that, regarding that new representation, there would be a privilege between her and the lawyer and the potential client. And so the judge maintained the privilege and denied the motion to compel. And then that client didn't waive the attorney-client privilege just because there was the previous joint representation. So our tip on that is, you can't control what someone else is going to give to you, but taking those good steps in that circumstance of saying, I can't represent you, I'm going to decline this representation. But you still need to maintain the privilege in that circumstance and confidentiality of the information that even a potential client gives you. And this also kind of brings up, which I'm sure happens to you guys all the time, is you have a client, you're working on a matter, the client says, oh, but what do you think about this? And it's completely different outside the scope of your representation. If you were interested in something like that, I think your response should be, that's so interesting. I'd love to get together a separate engagement agreement about that issue, or, I cannot represent you on that. I can't help you with that. I'm going to send you an email that says, I can't help you with that. And I'm your lawyer on this other thing, and not this thing that you're asking me about now. So our, the picket or it didn't happen point is, I feel like what people say all the time is, something like that is best when it's in writing. Contemporaneous documentation is helpful to have there to be like, we heard this, I heard you ask me that, and we're not going to represent you on that. And so we would encourage you to, stay within the scope of your engagement letter and the matter that is agreed, which takes us to Lindsay to talk about engagement letters.
Okay, so engagement letters, non-engagement letters, all of that could be the topic of an entire CLE. So I just want to hit some of the highlights here. And Jenny talked a little bit about the use of letters for determining the attorney-client relationship. And so that'll be our focus today. Just, why should you have an engagement letter? Well, there's a lot of reasons, but for purposes of today, it's a significant factor in determining whether there was an attorney-client relationship. So Jenny talked about the objective factors Well, that's one of the key factors, is whether there was an engagement agreement, particularly if it's part of the lawyer's practice, which we hope it is for you all, to have an engagement letter for every matter. Where you don't have an engagement letter, that suggests no attorney-client relationship. So it protects attorneys from liability, both in terms of the formation of the attorney-client relationship and on other issues. Of course, it's important for ensuring the payment of fees, but it also sets the parties' expectations from the very beginning. And so we'll talk a little bit about scope of attorney-client relationship and defining that within the engagement letter. So going to the next slide, this is a highlight of what to include in an engagement letter. Again, this could be an entirely different, CLE. So Jenny and I are both being plagued by our lights in our office. So I just want to focus really, for the purposes of this presentation, on defining the client and defining the scope of the representation, because that's important for whether you have an attorney-client relationship with someone. So for purposes of the client, be specific as to who the client is, and then have a specific statement or a general statement that you are not representing anyone else other than the defined client. So this comes up, for example, where you're representing an entity, but you're not representing the individuals. You want to be clear in the engagement agreement that you are representing company, not representing individuals or anyone else, so that that's clear to everyone, and the individuals, are not later able to claim that you also represented them. Now, for scope of the representation, again, the advice here is to be specific. If it's a litigation matter, define the litigation matter. Is that litigation matter going to include appeals, for example? So sort of think through the entire process and what all does that include. If it's a corporate matter, define the corporate matter. Is it a specific transaction, a specific deal? Of course, there are situations where people hire us for just sort of general advice, but it's dangerous to have an ongoing representation about just general business advice or legal advice. So be as specific as you can. And as Jenny said, separate engagement agreements for separate engagements will really protect you there. So Rule 1.02 of the Texas Disciplinary Rules specifically says that a lawyer may limit the scope, objectives, and general methods of the representation if the client consents after consultation. So in the example of litigation, you can limit your representation to only the trial matter, and that you're not going to represent the client on post-trial motion practice or in the appeal. That's fine to do, but that needs to be defined in the engagement agreement and have the client consent. So what's the best way for the client to consent? In writing, where it's documented. And the comments of that rule go on to say that unless the representation is terminated, as provided in Rule 1.15, a lawyer should carry through to conclusion all matters undertaken for a client. If a lawyer's representation is limited to a specific matter, the representation terminates when the matter has been resolved. So by defining the specific scope of the representation, there's typically a natural conclusion to the representation. And so you help yourself out by being specific there. I have a matter, just to give an example on this, where law firm represented a client. Lawyer of the law firm, sort of off the record, off the books of the law firm, did significant work for the client that the law firm claims they did not know about. So it's sort of a authority issue between the law firm and the lawyer. And the law firm, there's an engagement agreement between the client and the law firm, and it says that it's going to represent the client for general corporate matters. So the law firm's interpretation of that is what was presented based on the conflicts check is we knew that it was going to be about setting up some corporate entities and some trademark work for these entities. Well, client says, I understood that meant the law firm is going to represent me in this multi-million-dollar significant acquisition of another company, which is where the alleged malpractice, that's where the claim lies, is with the acquisition work. So law firm saying, we didn't represent you on that, client saying you did. And the engagement letter is not specific in that case. And so if it had been specific as to the type of corporate work, or, based on the client's view that it was going to include this acquisition, either way, that provides clarity for that representation. And so just beware of those sort of general descriptions of the matter in your engagement agreements, and try to be as specific as possible. So now we're going to talk about non-engagement letters. And a non-engagement letter is, I do not represent you. So it's sending correspondence in a situation where someone may think they represent you for one reason or another, and being very clear that I do not represent you. So some situations where this comes up, if you are evaluating a potential matter for a potential client, and you collect information from that potential client, and the representation ultimately does not come to be for one reason or another, it's best to send a declination letter, correspondence saying, hey, we discussed this potential representation, you or I, somehow we decided not to have the representation go forward, and so we're declining the representation, we're not going to be representing you. That is a very important correspondence if you have been discussing a potential matter with a client, so that it's very clear they are not relying on you to carry that matter forward, and would go on to say that, recommend that you consult with another lawyer. Maybe you can even make some recommendations for them if you're not going to take on that matter. Other areas where this comes up is multi-party matters, or also in the representation of an entity. So multi-party matters, my best example of that that we've dealt with is where a lawyer is representing the executor of an estate, and that lawyer in that role is dealing with the beneficiaries of the estate on behalf of the executor. And there's case law out there that lawyers who represent the executor of the estate do not represent the beneficiaries. But from the beneficiary's perspective, if you're communicating with them about legal matters, they may think that you represent them. And so in that type of situation, it's best to say, be clear with the beneficiary from the beginning, I do not represent you. I am communicating on behalf of the executor of the estate, but I do not represent you. And we have a matter right now where this is an issue, and our client represented executor of the estate, and that was known to everybody. But our client sent some correspondence to the beneficiaries of the estate, advising them of a one-time estate planning opportunity. It was in a year where there was no estate or gift tax. And so the lawyer sent it to the beneficiary saying, hey, there's this, I want you to be aware of this estate planning opportunity. And the lawyer was trying to be helpful. This is a significant opportunity. I want to make sure I advise the beneficiaries of it. And in the lawyer's mind, he was acting on behalf of the executor of the estate. Well, one of the beneficiaries sued the lawyer and law firm saying, I hit mute somehow, sorry. One of the beneficiaries sued saying, you sent me this correspondence, you represented me. That beneficiary was represented by other counsel, and there's a lot of other objective factors that suggest there was not an attorney-client relationship. However, if that correspondence to the beneficiary had said, I represent the executor of the estate, I do not represent you beneficiaries, that would be helpful. We don't have that evidence in our case, but that would be helpful. And so that kind of language is very important when you're communicating with someone who you are not representing. And then in the representation of an entity, naturally in representing an entity, and Jenny gave an example of this, you are going to be talking with employees of the entity. You obviously have to talk through employees and individuals of the entity, and you need to be very clear in those communications with individuals associated with the entity. I do not represent you. And again, it's best to always have that in writing. I will be interviewing you. I will be talking to you about this matter. I am not representing you. I am representing the entity. Rule 1.12 of the Texas Disciplinary Rules talks about organization as a client, and says that a lawyer in representing an entity shall explain the identity of the client when it is apparent that the organization's interests are adverse to those of the constituents. And so you need to be very clear about that. And the comment goes on to say that care should be taken to assure that individuals that you're dealing with understand that when there is adversity of interest, the lawyer for the organization cannot provide legal representation for the constituent individual, and that discussions between the lawyer and that individual are not privileged. And it's also best if you learn of adversity between the individual and the entity to advise the individual, you need separate counsel. I'm not your lawyer. And then another rule cited here is 4.03, and that talks about dealing with unrepresented persons. And that rule states that when a lawyer knows, reasonably should know, that an unrepresented person misunderstands the lawyer's role in the matter, the lawyer should make reasonable efforts to correct that misunderstanding. So when you have a sense, or maybe someone says directly that they think that you're representing them, you need to be clear with that individual that you are not representing them. And so just generally, again, we recommend these discussions be in writing, and the language would be clear that, we do not represent you, or we are declining to represent you. We are not taking any action on your behalf, and recommending that they find another lawyer. So, several different ways to make the same point that you are not representing that individual. Okay, so we're going to move on to our last topic here, and this is disengagement letters, or termination letters, terminating the representation. And while sometimes there is a natural conclusion to a representation, sometimes there's not. And either way, we encourage disengagement letters. So disengagement letters are essentially correspondence that's saying the representation is concluded and I no longer represent you. And I've included here a couple of other points that that are helpful to include in disengagement letters, such as dealing with client file documents, advising the client of your document retention and destruction policy, what you're going to do with the records, how long you're going to keep them, those kinds of things. But the important point of this for today is that the representation has concluded, and advising them of that. And this is important so that your obligations to that client have ended for the most part. There are confidentiality obligations that are ongoing even after the termination of the attorney-client relationship. But the fiduciary obligations of an attorney end when the representation is concluded. And so it's important to have finality there, and for both the lawyer and the client to know this representation is over. Rule 1.02, which talks about scope and objectives of representation. The comments there talk about that if a lawyer has represented a client over a substantial period in a variety of different matters, the client may assume that the lawyer will continue to serve as the client's lawyer unless there's a notice to the contrary. The comment goes on to say, and this is what's on the slide, doubt about whether a client-lawyer relationship still exists should be clarified by the lawyer, preferably in writing, so the client will not mistakenly think that the lawyer is looking after the client's affairs. So in the example of you represent a client in litigation, but you're not going to represent the client in appeal. Well, maybe that's in your engagement agreement. Maybe you've discussed that with the client. But still advise that when that litigation ends and the matter, if the matter, potentially is going to go up on appeal, you send a letter to the client reminding them our representation has concluded. If you want to appeal, here's information for that. And here's, maybe recommend other lawyers, but just be very clear that you are no longer representing them. And so again, encourage those to always be in writing, even if it's obvious, even if there's an order of dismissal or a settlement agreement, something like that in the litigation context, in the business context or corporate context, the deal has closed. Still helpful to have that disengagement letter so that you have finality as to the date. That's also important for statute of limitations issues and malpractice suits, but that's a whole another discussion. So that concludes our representation.
We do not represent you.
Not taking my own advice. That includes our presentation on the formation of the attorney-client relationship. We're happy to take questions in the chat. If anybody, I don't think I've seen any, but if anybody has any, we're happy to take those. We'll watch for those for a minute. And just another reminder that Maria is going to put in the chat the link for CLE. And so encourage everybody to click that link and make sure they get CLE credit.